I hope you're doing well. Thanks for having me and tuning in today. My name is Jeff Worley, and I'm an attorney with Gibble, Crable, and Hess. And I'm going to be talking today about wage and hour issues. Now, I've been watching some late night TV lately, and I am starting to feel for Jimmy Kimmel because his intros are dead. And it's tough. I'm here talking to you. I'm sitting in front of my computer. The only person I see is myself talking. And I'm recording this, and I don't know if anyone's watching this or not. So, that's what we're dealing with. It would be great to be there in person today, but we're here. So thanks for having me, and it's great to be here with you. So primarily today, we're going to talk about the Department of Labor, which is the DOL, the Fair Labor Standards Act, which is the FLSA, as well as corresponding state law. And I get that that's probably not the most exciting topic you're encountering during the annual seminars this year. But let's look at this simple example, and I'll show you why this is really important for you to keep in mind. Let's say a company employs 100 hourly employees. These are hourly, non-exempt employees entitled to overtime. And for simplicity's sake, let's just say that all these employees each earn $10 an hour. And each employee is scheduled to work 40 hours a week. Now, let's just say that each of these employees works an additional hour a week, but they don't record it and they're not paid for it. Maybe this is time they're spending reading reports at home, doing emailing, maybe they're staying later at work, but in any case, they're working one additional hour a week and they're not getting paid for it. And let's say now there's a DOL audit. So stating the obvious, these employees should have been paid overtime for that hour worked. Overtime for them because they made $10 an hour would be $15 an hour, time and a half. And so they're going to be now looking back a period of 2 years. The DOL will be looking back a period of 2 years in this audit to determine what the penalties are. So if they work 50 hours in a year, that's $15 a week that they were not paid. And then we multiply that by the weeks worked, and that's $750 owed for 1 year. Times that by 2, which is the look back period, and we're now at $1,500. And if we include all hourly employees, we times that by 100. And now we are looking at close to $300,000 in penalties. And if it is a willful violation, then the look back period is 3 years. So that's $450,000. And if we include the possibility of liquidated damages, which is double the fine, and generally you'd see liquidated damages in a private cause of action, we could be looking at $600,000. And one assumes, 1 hour of unrecorded time. Some of you employ, more than 100 employees. Some of you have folks who are working maybe more than an hour of unrecorded overtime. You begin to see how this can create significant liability for your organization. And we all know that one employee who really wants to go above and beyond. They're the all-stars. They're the employees who are willing to, drop things off at the office on their way home. They're the employees who are willing to take the call in the middle of the night to talk somebody through a situation. They're valuable. And a lot of times these folks are saying, hey, don't worry about me. I know that the company is running on a tight budget. I know that we've got people to serve. I know that I buy into the mission of the organization. I want to help. Well, that's a great contribution, but they need to be paid. They need to be recording those hours. And if they're not, we're going to have issues. Now, we're in the middle of the pandemic, and I'll say that not much in terms of wage and hour law are no exceptions being provided to wage and hour laws because of the pandemic. And as you may now have fewer employees than you did pre-pandemic. And as a result, you are dealing with more employees working overtime. Scheduling becomes an issue. And a lot of you probably have folks who are also working from home. Your administrative staff, maybe working from home, working remotely. And a lot of those folks are going to be hourly as well. And as anyone who's working at home knows, it's really easy to start blending your home life and your work life, and where one begins and where one ends isn't always clear. So, what we're going to talk about today is sort of who's exempt, who's not exempt, and some of the pitfalls and some of the considerations that you need to take into account when considering these matters. This is going to be a general overview, sort of a basic primer, but we're going to get into some nuances as well. And I should say that this is, a general overview. This is not legal advice. Your situation is going to be specific to you. And as such, contact your attorney, when you encounter a sticky situation. So let's start with the basic premise of exempt versus non-exempt. Your exempt employees are exempt from overtime, meaning they work 20 hours, they work 120 hours, they get paid the same amount. They get paid a salary, versus your non-exempt employees who are paid overtime. They record all their hours and they're paid overtime. Non-exempt is always going to be the default. You can pay any employee as a non-exempt employee. You can pay your CEO by the hour if you choose to. But in order to get to exempt, you are going to have to pass two tests. And that is going to be the duties test and the salary test. The duties test looks at what duties does the employee perform. And I should mention here, there's a handout that's accompanying this, and you can look at the handout as we're going through this presentation today. And on that handout will be some of the duties tests laid out in more detail for you. And I'd also say that the DOL has a great resource as far as the duties tests go. But the duties test does look at what are the duties that the employee is performing. And generally, those are going to be executive, administrative, professional, and certain outside sales roles. And I'm not going to get into all the nuances of what those duties entail, but I note that it's not in name and title only. This is going to be really what does the employee do? Not just what the job description says, but what do they actually do? And are they exercising discretion? Are they exercising supervision? Do they have a role in the organization that allows them to make decisions? Those are going to be the questions that are going to be looked at when we're considering, do they perform exempt duties or not? And then the second test is the salary test. Does the employee make enough money to be considered salaried exempt? Currently, that's $684 per week. Now, that's the federal and state currently is at $684. In Pennsylvania in 2021, that's going to be going up to $780 a week. And then in 2022 to $875 a week. So that's something you're going to have to keep in mind and continue to review your salaried employees and making sure that they are making enough. And that's something that maybe is an important thing now to also consider, whether or not in 2022, will your employees be making that amount? Because that's going to be an important consideration, and you might want to start thinking about that now if you need to transition somebody to an hourly role versus keeping them in a salary role. So the employee needs to meet both of those tests. If the employee does not meet one of those tests, then the employee will be considered non-exempt and the employee will be entitled to overtime. If overtime is not paid, then we go back to our hypothetical at the beginning. So let's look at hourly employees and a couple of issues that can arise with hourly non-exempt employees. An hourly employee, like I said, is entitled to be paid for all time worked. And pay time is the hourly rate, which is established. That should be a set rate. Some of you may have fluctuating rates for sleep time, and those are established as well. And that creates a little bit of a complication when you're factoring in when you're calculating overtime. And that's something for you and your payroll company to kind of discuss as to how that works. But generally, their overtime rate then is going to be 1.5 times anything above 40 hours in a work week. Now, let's say we have an employee named John, and John works in a residential home that serves the IDD population. John's an hourly employee, and John's scheduled to work 40 hours a week. Now, unbeknownst to his employer, John has been staying after work, after he's scheduled to work, working, helping around, cleaning up, interacting with the folks who live at the home, generally doing stuff that he would do while he's working. And no one's asked John to stay after work. I mean, and again, John is the employee that you want in many respects. He's the person who's engaged and he's hanging out, but he's working longer than what he's scheduled. So he's working overtime. No one's asked him to work overtime, and he's not recording his time either. So he's not getting paid for the overtime. John never asks to be compensated for this time either. What should an employer do when the employer discovers that John has been working this additional time? The employer must pay John, even though John wasn't scheduled, even though John's not asking to be compensated, even though the employer's like, what's going on? I got 10 additional hours from you, John, now that I've got to pay you. And that, that's a substantive amount of money. And maybe they didn't even need John there. There was already coverage at the home. There was already, enough staff. He was just chipping in and helping out. The employer still has to pay the employee for the overtime worked, regardless of whether the employee was scheduled, or whether the employee asked for the overtime. Now, the employer can also write John up, and the employer can certainly direct John, don't work overtime. We'll pay you for last week. Don't do it this week. And if John continues to do so, yes, he should be written up. And eventually, and I've had this situation happen before, where we've actually had to terminate an employee because the employee continued to work overtime when they were told not to work overtime. Now let's look at Mary. Unlike John, Mary darts out at the end of her shift. She is in and out and done. Mary works for 40 hours and goes home. Let's say that the employer has suspended John because of John continued to work overtime. So John's now suspended and they need additional coverage. So they come to Mary and they say, hey, Mary, we'd like you to work on Saturday. And Mary says, I'm not scheduled to work on Saturday. That would be overtime. I work 40 hours a work week, and that's all I do. Can the employer force Mary to work overtime? And the answer is technically yes. Now, obviously, the employer can't go over to Mary's house and force her to get in the car and take her over to work and force her to work. But at the end of the day, the employer can opt to tell Mary, you need to work. This is required overtime. And if you don't work the overtime, we're going to consider it a no-call, no-show, and you'll be terminated. Not not an ideal situation, but certainly within the employer's prerogative to force Mary to work overtime if it would choose to do so. Now, as a slight caveat here, would Mary be entitled to unemployment compensation if she's fired for not working overtime? Probably so, because her schedule is not such that it included the overtime. Might come back somewhat to what the employer's policies are, what's in the handbook. And so it's an important component, I think, to include in your handbook that overtime may be required. It may be important to include that in the job description as well, that overtime from time to time will be required. So Mary doesn't work the overtime, and now the employer is really scrambling to find coverage for John's shifts and Mary's shifts. And the employer asks Frank to cover some shifts. Frank was hoping to get away for a couple days later in the month. And Frank comes back to the employer and says, look, I'll work the additional hour this week. I'll put in on the Saturday. But later in the month, I'm scheduled to work Thursday, Friday. How about I work this week, and then in a couple weeks, I can take a couple days off. I don't get paid for my time this week. I'll just flex it for a couple weeks from now when I want to get away for a few days. Is that an allowable arrangement? And the answer really comes back to, well, is Frank exempt or not exempt? If Frank is an exempt employee, then absolutely. He can flex his time. Frank can work 20 hours this week and work 80 hours the next week. And you may have some of those employees where you're coming back to them and saying, look, you've been putting in 60 hours consistently for the last 2 weeks. I want you to take off on Friday. They're going to get paid the same regardless. And so, as an exempt employee, that's permissible. But as a non-exempt employee, that is not permissible because, again, the employee must be paid for all hours worked within the week that they work it. Let's say an employee is making $10 an hour, and then the pandemic comes along. Let's just say there's a pandemic, and the budget is hit, and the employer needs to cut compensation because that's the only way they're going to stay operational. Can an employer reduce an hourly employee's compensation? And again, not an ideal situation, but yes, an employer can do so. The employer must pay the employee their hourly rate that was established up until the time that a new hourly rate is established. But yes, as long as the employer is paying the employee minimum wage or above, the employer can cut an employee's hourly compensation. Again, not talking about what's good for team morale, not talking about what's going to make an employee feel good, but what's legal, yes, it can happen. What about vacation time, sick time, or other paid time off? Do they count when we are determining overtime? They do that time, that paid time off, and we'll just use the bucket of paid time off, does not have to count towards the overtime calculation. And that's really up to the employer. The employer can say, and it should be said in the handbook, if this is the employer's practice, that on paid time, the paid time off, whether that's PTO, sick time, or holidays, is not considered for overtime calculation. And an employer can also say, we do not consider paid time off, vacation time, sick time as counting towards the overtime calculation, but we do count holidays, because I have some of my clients come to me and they say, look, my guys, my workforce, they count on overtime, and we generally run a 55-hour week, work week, and everybody's counting on that over the summer or whatever the time frame is, where we're really putting in a lot of extra overtime. And come Memorial Day, I don't want to penalize them by giving them the day off, but then they don't get the overtime at the end of the week, and so we're going to allow holidays to count towards overtime calculation. So it's really a matter of what the employer wants to do here. So something to keep in mind. But if you are going to provide that the paid time off is not included in the overtime calculation, that should be explicitly stated in the handbook. The only other thing really that the employer needs to consider, and that's maybe a bit of a broad statement, the only other thing that the employer needs to consider. There's a lot of things to consider here. And again, as I mentioned, each situation is going to be specific. And so, we're going to need to look at the specifics of your situation as something arises. But one of the other major considerations that an employer needs to keep in mind is documentation. So all of your hourly employees must document all hours worked. And the employer needs to keep a record of this, because if there's a DOL audit, the DOL auditor is going to want to look, and they're going to want to look, probably 3 years back. And so at a minimum, you need to be keeping your payroll records for at least a period of 3 years. And that runs, as I mentioned, with audits or private causes of action, much of this is going to come back. Now let's look at exempt employees. They're a little bit more complicated because, as we mentioned, there are these various tests that you need to consider. The employee needs to pass those in order to get to a place where we can consider them to be exempt. The salary test is very straightforward. Are they making enough money? Done. But the duties gets more complicated for each position, and that's why an employer will want to have a detailed job description for each salary position. The job description is going to be important for your hourly employees, and there's a number of reasons why a job description becomes important, not just in terms of wage and hour considerations, but your Americans with Disability accommodations. We're going to be looking at what are the essential job functions. Is there a lifting component? Is there a standing component? Can the employee perform those essential job functions? So there's a lot of reasons why a job description is important. But when we're looking at your exempt employees, that's going to establish that they are performing exempt functions and that those exempt functions are, in fact, an essential part of their job. Now, as I mentioned, it's not just the job description. It is, in fact, what is the employee doing? And I've worked with employers through this process where the job description says that this employee has a lot of discretion and a lot of decision-making capabilities, and the job description reads perfect. And then we go in, we talk to the employee, what do you do? And, I take, things from point A and I put them over at point B, and I move things from point B to point C, and that's what I do all day long. Where's the decision-making capabilities? Where's the discretion? It's not there. Likely, they're going to fail that duties test. And with those DOL audits, a lot of times you will have the auditors coming in and actually interviewing employees and getting to know what is it that they do. And of course, if you have a private cause of action, the private cause of action, is going to be brought by an employee. They're going to be represented by an attorney, and that attorney is going to be cross-examining you, your HR staff, other employees as to their duties and what they did, and making it, trying to make a factual basis for the allegation that the employee should not have been exempt. Should not have been exempt. So, we have the executive, the administrative, and the professional and certain outside sales exempt categories. And those are the categories that the DOL says qualify as exempt. The DOL also says that certain computer professionals and other highly compensated employees, those making more than $107,000, are also exempt. However, under Pennsylvania law, there is no exemption for computer professionals, and there is no exemption for highly compensated employees. And so that's something to keep in mind, that under Pennsylvania law, those exemptions do not exist. And so when you are looking to your computer professionals, you need to look and consider, do they have administrative functions? Do they have supervisory functions? If they do, we may be able to get them under an exemption for that. But in and of itself, there is no exemption for computer professionals in Pennsylvania. Another thing particularly relevant for you folks, when we look at the professional exemption, That is a very nuanced exemption, and that requires that the employee's primary duty must be the performance of work requiring advanced knowledge, predominantly intellectual and characteristic. The advanced knowledge must be in the field of science or learning, and the advanced knowledge must be customarily acquired by a prolonged course of specialized intellectual instruction. I say it's relevant to you folks because a lot of organizations classify their caseworkers and their social workers as exempt. Most of your social workers, your caseworkers will have bachelor's degrees, and isn't that enough to get them? As mentioned, that exemption requires specialized intellectual instruction. And that means more than simply a bachelor's degree in social services, human services, behavioral sciences, or an allied field here. It requires specialized focus. And some of the ways you can get that exemption for your caseworkers or your social workers would be through a master's degree. So if the person has a master's degree in social work, your MSWs, masters in counseling, those folks would qualify as a professional. A bachelor's degree in human behavioral science, which includes 30 semesters or 45 quarter hours, either in development of human behavior, child development, family intervention techniques, diagnostic measures, therapeutic techniques, such as social work, psychology, sociology, guidance counseling, child development. Those are areas where likely you're going to meet that professional exemption. Again, for each situation, it's going to be specific. So again, talking this through with your attorney, talking this through with your HR staff, and making sure that, in fact, that person meets that professional exemption. Because, and another thing to keep in mind is you cannot use years of service to meet the professional exemption. So you might have a caseworker who's been at this for 20 years, and they may know their stuff a lot better than somebody who's come in newly minted out of school with a master's degree. That person who has 20 years of experience will not meet the professional exemption simply based upon their experience. Whereas that newly minted MSW will meet the exemption likely. Another question is, what happens if some of your caseworkers meet the exemption, they have the educational background and they meet the exemption, and you have others who do not? What do you do in that situation? Obviously, the preferred categorization of your caseworkers, your social workers, for a lot of those employees, the preferred way of characterizing them would be under exempt, because that gives you and them both a lot of flexibility, a lot of ability to determine what the annual rate of compensation is going to be. It's a lot easier on your budgetary constraints. Can you have employees who some of them are exempt and some of them are not exempt? Technically, yes. As a general rule, my advice is you have 2 separate job descriptions, providing it may be social worker 1, social worker 2. Under social worker 1, it has the professional exemption. It would have the educational requirements as to it. And then you have social worker 2, which would have less of the professional requirements, and they would be hourly. Another question that arises is, what do we do with employees who don't meet the salary basis? As we were looking earlier, the salary basis in Pennsylvania is going to continue to go up. And at some point, you may have folks who are simply not making enough, and as an organization, you do not have the resources to continue to increase their salary. You might have other folks performing the same position who are making enough of the salary, and so they can remain exempt. technically, again, you can have folks in the same position, some of which are hourly, some of which are salaried because of the salary basis. That's generally not good for morale and for how, a good working cohesive team environment, because you're going to have some folks who are making overtime and some folks who are not. And most employees really prefer to be exempt. There's a feeling that the exempt status carries some clout, that it somehow means you're more of a professional. On the other end is, your hourly employees get paid by the hour. And so they're getting paid for all hours worked. And, if they're at home reviewing reports, checking emails, going over things, they are going to be entitled to that overtime, whereas the exempt employee doing the same thing will not. And so again, if you have folks in and building up there, because some folks are going to be getting paid for time when other folks will not be. And when we talk about the economic downturn that some of you have experienced, the other question arises: well, can we reduce a salaried employee's rate of compensation? Can we reduce their salary? And the answer is yes, you can. Again, not an ideal situation, but it's possible. The things to consider are that the reduction is permanent. And when I say permanent, we're looking at, a period of roughly 3 months or longer. This isn't a fluctuation of this week our coffers are full, we're going to pay you at this rate. This week they're not. That's not a way to do things, and you'll lose your exemption. The salary reduction should be applied to an entire group or class of employees. And it's not directly tied to a reduction in hours. So, if an employer temporarily reduces an employee's salary when business is slow, this will likely change the exempt status, because as we talked through, the exempt employee gets paid the same salary regardless of 20 hours or 120 hours in the work week. And so if work becomes slow, that should not affect salary. So it shouldn't be directly tied to a reduction in hours. And as I mentioned, that should be a permanent reduction, 3 months or longer. When we're looking at those, a couple weeks here, a couple weeks there, again, the DOL is going to look at that and say, hey, that looks like the employee is being treated like an hourly employee, and we're going to now cause that employee to lose the exemption. And you, as the employer, might not realize that you've lost the exemption at that time. It may only come to light at a later point that the employee has lost the exemption. Well, from the point that the employee's lost the exemption up to when the audit is, that employee is going to be treated like an hourly employee. And you're going to have a situation where you may run the risk of having to pay a lot of overtime to that employee for that period of time. That also brings up the question of, should I then be tracking my exempt employees' hours worked? Because that's one of the perks, in a way, is we don't need to track their hours. They kind of come and go as they please, and there's a lot more flexibility. This does illustrate one of the benefits of having an exempt employee track their hours, though, because you can now demonstrate, here's how much that employee worked in the event of an audit and in the event that the employee is deemed to be misclassified. Another benefit to this, and I would strongly encourage you to do this at least on an annual basis, is to have your exempt employees record their hours in a work week in a certain period of time, so that you are gauging how much that employee is spending on the tasks that they're doing. That gives you a better sense of, we have a job here, we think it's a 40-hour work week, we have an employee who's spending 60 hours on this. What's going on? Where's the difference between the 40 hours and the 60 hours? And what can we do as the employer to ensure that this employee is, clocking out at the end of the day, spending time with their family, getting to their kids' soccer games, whatever the case may be. And we're not looking at an employee who's potentially going to burn out in a couple of years from now because they've consistently worked, 60, 70 hours of work week. And I know that particularly in the, the field of caring for people in this, range of services that you all provide, it's really easy to continue to clock in those hours after, you're at home. And my encouragement would be just to really look at how much are your exempt employees working, and really looking at, are there things that we can do to help reduce those hours if we're seeing a large increase, and also looking at what's the employee doing. Are they being productive? Are they, utilizing their time in a productive manner? Are there ways that we can help them do more? One additional thing I want to mention too is when we talk about your non-exempt employees, your hourly employees, and we talk about, they need to be paid for all hours worked. Well, what does it mean to say all hours worked? When we talk about work, it's, something that benefits the employer. And, a lot of times in, a factory situation, well, the employee's making widgets, and that's what they do. In your case, you look to, is what the employee is doing, does it benefit the people we are serving? And if the answer is yes, then they're working. Does it benefit the organization? If the answer is yes, then the person's working. And sometimes, that's a question of, well, they were at the office, but they're wasting time. They're still at the office. That's still going to be considered a benefit to the employer. If they're sitting at home, they're reading reports that they could have been reading while they were at the office, but they're choosing to do it at home. Is that a benefit to the organization? Yes, it is. And so really any hours worked, and how we think about worked is going to be, are they spending time doing stuff for the employer? And those de minimis, those, little increments here and there that may come up in an evening where somebody's emailing to say, hey, am I on the schedule for tomorrow? That's likely not going to be considered hours worked. Now, if somebody's going through the schedule and they're spending an hour arranging the schedule, that's going to be hours worked. But those increments of a couple minutes here or there, somebody calls up and says, hey, where's the, where are the car keys? That's not going to be necessarily considered hours worked. The other thing I want to mention too, and I did a presentation last week to RCPA on the Families First Coronavirus Response Act, the FFCRA, and I believe that's archived for your viewing pleasure if you would like to go back and look at that. But one of the questions that I've been asked is, does the FFCRA, the extended FMLA, and that extended FMLA is provided to parents who need to care for a son or daughter because the school or daycare is closed, how does that apply to salaried employees versus your non-exempt employees? And it applies equally to both. And that's just a point of clarification that both your exempt and your non-exempt employees are eligible for the FFCRA, the 2-week leave, whether that's for quarantine or other factors, and then they are also eligible for the additional 10 weeks of the extended FMLA. With your salaried employees, you're still compensating them at the 2/3 rate under the FFCRA. And so when we talk about that fluctuation in salary, there are allowable instances when that salary can be reduced, and that is one of the allowable times when the salary can be reduced. Otherwise, when you're looking at a salaried employee, they are paid the same salary regardless. Now, again, there are going to be situations where an employee may be furloughed, and if that employee is off for a period of time, and they are performing no work during that period of time, then they will, then you can not pay them during that time period. But again, that should not be tied to their performance or otherwise tied into factors that are not related to the actual furloughing, where you have the employee who is simply not working for a set period of time. One of the takeaways from this, is to be aware that this is an issue. There are a number of factors that play into the classification of the employee, and then there are a number of factors that play into how that employee is paid and what the employer can require. It's a complicated issue. There's a lot of missteps that can happen along the way. And as we've illustrated at the beginning of the presentation, there can be huge penalties for missteps. And so be aware that this is an issue, and also be aware that you don't have to necessarily be an expert on this. It's more about issue spotting, and then to look at this and making a determination as to what needs to happen. But it's always important for you to be proactive and to be on the front end of this, as opposed to being on the receiving end of an audit and looking at a DOL auditor or plaintiff's counsel during a deposition. I'd say please be in touch with any questions that you might have. We're here at Gibble, Crable & Hess to answer any questions that you might have. Thanks for spending your afternoon or your morning, or hopefully not your evening, with me. And be well, take care. Thank you.